to winning isn't easy. The standard of review is crucial. So let me tell you the story of Ms. Castor. As I've pointed out, Sedgwick has a nasty habit of denying benefits during a short-term disability period. And it's particularly true just as the claim starts to transition from short-term to long-term disability. That's a pattern I've noticed over the many years that I've been involved in handling ERISA disability claims. So let me tell you the story of Castor versus AT&T Umbrella Benefit Plan. Castor was a 15-year employee of Ohio Bell Telephone Company, and she became disabled as a result of abdominal and intestinal problems. She filed a claim for short-term disability benefits, and just as she recovered from the infection involving her digestive tract, she was hospitalized for congestive heart failure and atrial fibrillation. Now, just before her 52 weeks of short-term disability benefits expired, her cardiologist suggested that she had improved and she could return to work. So guess what? Sedgwick did a file review, and their liar-for-hire peer review doctor opined that she could have returned to work weeks before she started having these difficulties with her heart. Now, instead of challenging the denial on the basis that she still remained disabled as a result of either the gastroenterological problems and the cardiological problems or the gastroenterological problems alone, she changed tacks. And she now claims she was disabled as a result of a psychological issue. When you look at the medical records, there was nothing but psychological symptoms. And of course, you would expect that Sedgwick's paper review doctors would say that she would be able to work from a psychological standpoint. And that's exactly what happened. So she files a claim. Ultimately, that's denied. The appeal was denied. And then she files a lawsuit claiming that it was improper for Sedgwick to use the same doctor who had reviewed the file at the time of the initial denial a second time around. So the same doctor got a second bite at the denial, but for a different reason. And what the court said was, well, look, just because Sedgwick used the same doctor on the appeal to review this new claim of psychological issues isn't arbitrary and capricious, particularly since Sedgwick actually had two new doctors review the psychiatric aspects of her case. And as expected, they felt she was capable of working. Now, she also claimed that this was arbitrary and capricious, which is really a handcuff on judges. And she argued that the judge should overturn this denial because the peer review doctors did not have the full information about her occupational duties. And again, this was not a well thought out case, I think, because the peer review records actually did address the occupational issues in her case. So I think it takes an understanding of the games that plan administrators like Sedgwick engage in. They're going to be using this arbitrary and capricious standard of review to create evidence that will support a denial that will be upheld by the court. And arbitrary and capricious isn't what you think it means. It's not that it's arbitrary and it's not that it's capricious. It's basically, in English, means that it's not supported by something in the record. And of course, that something is something that the disability carriers have created through their liar-for-hire peer review doctors. That isn't to say cases can't be appealed, but you've got to understand the game. And you can see in this case, it was an easy win for Sedgwick, and the court upheld the denial. Got it? Let's take a break.